So today I'm going to be talking about rights for tenants. Many of my presentations have been landlord oriented. Today is going to be for both, but with a special emphasis for tenants who are interested in what their rights are to have an assistance animal. This includes companion animals, emotional support animals, service dogs. So California has very specific rules, very strict rules, very generous rules for service dogs, emotional support dogs, companion animals, even more than federal law already provides under the ADA. Assistance animals is a very broad category. And what does the category of assistance animal include? Well, if you want to look up in detail, go to California Government Code section 12185, and that refers to assistance animals. So the category of assistance animal, again, is very broad. It includes guide dogs, signal dogs, service animals, and support animals. And for further detail on assistance animals, in addition to going to California Government Code 12185, you can see more detail about the enumerated examples if you go to California Government Code 12005, subsection D. So service animals are the most protected. I think we're all familiar with service animals. Now, obviously, we've probably seen some service animals wearing a service animal vest that kind of make you wonder, really? But this is where you have to be very careful if you are a landlord. Do not base the determination of whether it's a legitimate service dog or not based on your experience, your own subjective opinion. That is one of the paths that lead to a lawsuit. And when it comes to service dogs, service animals, disability rights, what you could find yourself in as a landlord is a world of legal hurt beyond just the traditional, oh, I didn't give the security deposit back in 21 days, which is bad enough. Now we're talking about potential violations of state law and federal law. So if you are a tenant who feels they have been wrongly deprived of a reasonable accommodation, you should talk to an attorney, especially someone who knows the Americans with Disabilities Act law very well. There's certain specialists in the legal profession that do nothing but ADA litigation. So, what is a service animal? Well, the difference between a service and a support animal, I'll talk about that in a moment, but these are guide dogs, signal dogs that are service animals. These are animals that are trained to perform specific tasks to assist individuals with disabilities, including individuals with mental health disabilities. So don't just look for the physical ailment, medical device that the individual with a disability is dependent on to get by in ways that they cannot without. Don't assume that because you can or because you can't see their disability that they should be treated the same as an able-bodied individual. So, a service animal, like I said, is entitled to have access to all the dwellings that are available to use by the tenants, occupants, invitees, owners, and others, regardless of any kind of breed, size, or property, no pets restriction or policy, unless the animal has a history of posing a direct threat to health or safety of others. Now, when a new or existing tenant informs management that they have a need for a service animal, the only two questions that a landlord or agent can ask are, one, are you a person with a disability? And two, what is the disability related task the animal has been trained to perform? Now, keep in mind that you are not allowed to ask follow-up questions, such as, well, what kind of disability do you have? Or can you demonstrate the disability related task that this animal has been trained to perform? That is a guaranteed path to a lawsuit, pretty much. So, again, the only two questions you can ask are, one, right on the screen, are you an individual with a disability? And two, what is the disability related task the animal has been trained to perform? That is how you can ask whether the animal is a service animal. People get in trouble because they ask questions that they feel are appropriate and are not. So you cannot ask the individual to demonstrate anything, but you can ask the individual to provide the service animal certification. Now, they're not necessarily going to have that on them at all times. Some of them do, but they're not necessarily going to. That's not a reasonable request, but you shall give them a reasonable opportunity to provide that certification. And if they are requesting this accommodation at the time of the lease signing, well, that would be a good idea to request it before the lease is signed, before the security deposit is accepted. And an online certification is also valid if it includes an individualized assessment from a medical professional. Now, I'm going to talk about what an individualized assessment must include, but if you want to see details under the law of what individualized assessments generally need to include, look at Government Code Section 12178, subsection F. Now, who is authorized to verify a resident's disability? Well, the landlord cannot only require a doctor's note. Some landlords require a physician to state, oh, this is a legitimate service animal. This is an individual who's been under my care. No, you can't just request it from a physician. Verification can be provided by any reliable third person who has specific knowledge of the person's disability and or disability-related need for the requested accommodation. And this can include a medical professional, a healthcare provider, even a person from a peer support group, which is why I have this video here, as well as a non-medical service agency representative, a family member who cares for the individual, even in some cases self-verification, such as if the tenant were to show receipt of government disability benefits. Okay, so I told you about individualized assessments. Now, an individualized assessment can be required by the landlord if the person is attempting to provide an online certification of their service animal. So California passed a law recently that said you cannot, as a provider of these certifications, just issue blank certifications. You have to provide some kind of individualized assessment, basically. It's more complicated than that, but they're trying to both balance the needs of housing providers as well as public accommodation providers like airports, airplanes, as well as the needs of the individual, of course. So one place to look is California Government Code Section 12178, subsection F, for individualized assessment rules. And an individualized assessment is a type of assessment based on information that demonstrates that the individual, 1, has a disability, 2, describes the needed accommodation, including the species of the animal, and 3, describes the relationship between the individual's disability and how the requested accommodation is necessary to afford the individual with a disability equal opportunity to use and enjoy a dwelling or housing opportunity. Next, can a landlord charge a security deposit for an assistance animal? Well, the short and only answer is no. Look at California Government Code Section 12185, subsection D2. An individual with an assistance animal shall not be required to pay any pet fee, additional rent, or other additional fee, including additional security deposits or liability insurance, in connection with the assistance animal. And what this is doing is ensuring that people who have a legitimate need for a legitimate service animal are not penalized and treated in a disparate manner from other applicants who don't require that service animal. Now, obviously, if someone has just a pet, that's fine. But these are not to be considered just pets. These are implements for disabled individuals that, according to the essence of the law, one would believe a person would not need or even want one of these animals, even though we all love dogs, if they didn't have that disability. And most people would prefer not to have a disability, even if having that disability give them access to their dog 24 hours a day in all places they go to. Obviously, I love my dogs. Sneak peek behind the scenes, saying hi, Steve. But I realize that he is a pet and not a service animal. So when can a request for an assistance animal be denied? Well, before a landlord can deny a reasonable request, the landlord has to make a reasonable claim of undue burden. So the landlord must determine whether the burden is truly undue. Now, this must be the result of a case-by-case analysis, which looks at the individual circumstances and can consider the financial resources of the landlord and the availability of less costly alternative accommodations that might be equally effective. So keep in mind that it's rare that a reasonable accommodation request for a service animal or support animal would constitute an undue financial or administrative burden on its own. It's usually tied up with something else that would kind of tip the threshold in favor of the landlord saying this is going to be an undue burden. So whether an accommodation would constitute an undue burden upon the landlord should consider the following three elements. First, undue financial and administrative burden. In other words, it would cause such substantial financial burden to the landlord that it's just undue. Next, fundamental alteration of the services of the landlord. So it would cause fundamental alteration to what the landlord is providing. And some of these kind of blur together. Like if they had to install a very elaborate wheelchair ramp for just one individual, that would probably be considered maybe an undue burden on its own. But you would also look at the other factors. And then 3, direct threat to the health and safety of others. Now, this is probably the easiest element to meet, assuming there's a documented history of threats to the health and safety of others or significant damage to the property. Keep in mind that most, not all, but most legitimate service animals are expertly trained. These are the true service animals that have gone through thousands of hours in some cases, at least hundreds of hours of certification training. So they are accustomed to all types of environments. They're accustomed to screaming and children pulling on them, and they don't react. They don't bite. They are incredibly calm. They're amazing animals to watch. But unfortunately, with every law, there will be people who violate the law and violate the essence of the law in this case. It's not to say that they're necessarily criminals, although if you falsely represent your animal to be a service animal and it's not, you could face fines and some public accommodations. But what we're talking about right now is if you have a dog or other authorized service animal that is creating a very real threat or has already injured somebody or property, that is probably prima facie reasonable undue burden for the landlord to endure this dangerous animal. Because even if the landlord wants to do the tenant a favor by allowing this dangerous animal to remain on the premises, the landlord is incurring a sizable amount of liability by doing so. So in other words, if there's a direct threat to the health and safety of others, you have to use relevant evidence to determine whether an assistance animal imposes a direct threat. And that could include whether there is evidence that the animal in question is currently engaging in dangerous conduct or has a recent history of overt dangerous acts, which are further described if you look at Food and Agriculture Code section 31601. And a dog that has been finally determined by a court of law to be a potentially dangerous dog or vicious dog, pursuant to another Food and Agriculture section, same one, 31601, shall presumptively be considered to pose a direct threat to the health or safety of others. Okay, so I've tried to include the relevant primary source for this information. I've put it on the screen. I've also mentioned it in some cases. So I hope